good evening, and a very warm welcome to this lecture meeting on recent judgments and jurisprudence on GST. And respected Senior Advocate Vikram Nankani, sir, Chairman of the Indirect Tax Committee, Govind Goyalji, my office bearer Mandar, and Dushan Bhai, the convener of the Indirect Tax Committee, and all members and attending non-members of Bombay Chartered Accountant Society. Vikram Bhai, at BCS, the history of Wednesday lecture meetings goes when it was incorporated or formed. It was a group of chartered accountants who met every Wednesday, and that custom and ritual continues even today, where most of our lecture meetings we do on a Wednesday. Today is one such lecture meeting on a very, very interesting subject on goods and services tax. And we have the benefit of none other than Vikram Bhai Nankani to walk us through on the subject. As a society and as professionals in general, we have seen the GST legislation evolve from the legislation part, then the implementation part. And now I think we are at a phase where a lot of jurisprudence and judgments are something that are forced on the part. And it's very important that we understand some of these nuances and the threads that we are getting as far as the jurisprudence is concerned, especially given that it's a tax law. So Vikram Bhai and all members, once again, a warm welcome. Over to Mandar to introduce Vikram Bhai, and then we can take the session forward.
Yeah. Thank you, Anand. Friends, it is a pleasure and an honor to introduce Vikram Bhai. Vikram Nankani, he is a BA and completed his LLM in the year 1988 from the Government Law College, Mumbai. He is the fellow member of the Chartered Institutes of Arbitrators, London, and is also a council member of Mumbai Center for International Arbitration. Vikram Bhai was called to bar in the year 1986. Thereafter, he headed the dispute resolution practice at ELP since 2003 until he was designated as a senior advocate by Bombay High Court in the year 2014. Vikram Bhai joined the chambers of Mr. Ashok Desai, the former Attorney General of India. Over the years, Vikram Bhai has appeared as counsels in the variety of disputes concerning commercials and corporate laws, economic and criminal offences, taxation law, admiralty laws, etc. He also regularly appears before various high courts and Supreme Court of India. Vikram Bhai has to its credit several landmark judgments that have been reported by various authorities in various journals and reporters. Vikram Bhai has also been invited as a legal expert on various occasions, including in foreign courts and arbitration proceedings. Over the years, Vikram Bhai has successfully represented the interest of several Indian and foreign clients in an ad hoc and institutional arbitrations in India and internationally. With this, I welcome Vikram Bhai and I request Vikram Bhai to enlighten the audience about the recent judicial decisions in the GST. Over to you, Vikram Bhai.
Thank you, BCS, for having me. And thank you, Anand. Thank you, Mandar, for the kind words. Let me straight away launch into the subject because the topic is very simple. We are only looking to see the evolution of GST law as recently as last year and see how the courts have looked at certain factors which have their own nuances. So let me begin first straight away with the judgment which I consider that has been one of the leading judgments of this year, and that is the Safari Retreats judgment, which actually had its origin in the service tax regime, but the spillover effect into GST had also significant interest. Just to recapitulate what the issue was, that here was a gentleman who had invested in constructing a building, a mall, and he wanted to lease out the mall, of course, to others and not just sell or transfer the title in the property. His business model was such that he would construct for the purposes of leasing. Leasing, as we know, both under the service tax regime as well as under the GST law, is an output service on which the tax is payable. So the question arose that if he is going to construct, not for the purposes of selling an immovable property or transferring an under construction unit, but instead he is going to lease out, then the question which arose is that can he take in input tax credit? Because there is, as you would know, a bar on taking in input tax credit in mobile property services. The exception in works contract would be that unless you're using the input service itself for furtherance of a works contract. In such a scenario, would the bar be applicable if he was going to ultimately also discharge his tax liability? The overarching principle behind this bar or restriction in availing the input tax credit when it comes to works contract or construction services was that according to the government, these immobile properties were outside the framework of GST or service tax. And since there was no output liability as far as a immobile property is concerned, because the sale of immobile property was not part of the GST or the service tax framework, therefore we will not allow credit to be taken. Now, of course, there was a paradigm shift between VAT regime and the service tax regime on one hand pre-July 2017 and post that, as we know, because all the taxes were subsumed by the 101st Constitutional Amendment. So whether this argument of the government would stick on even post GST was something to be tested in the Supreme Court. It was, of course, the argument of the SSC, amongst other things, is that GST is a destination-based tax, it's a consumption-based tax. Your entire debate or working papers or the consultative committees had opined that you want to reduce the cascading effect. You want to ensure that credit is available at every stage because what you seek to tax is only the value addition. And therefore, don't look at the activity or what I am doing, but look at ultimately, am I giving you a tax on the output or not? Because if I am going to give you tax on the output, then their value addition continues even after the coming into existence of an immovable structure. These were the two broad rival arguments, one by the government, the other by the SSC before the Supreme Court. And of course, the direct challenge to Section 17(1)(c), which related to works contract, and 17(1)(d), which related to construction of immovable property. These were directly challenged to say that they are violative of Article 14. And of course, 19(1)(g) is always thrown into the mix for the sake of making it more attractive. 14, as you know, is if it is manifestly arbitrary, and 19(1)(g) if it violates your fundamental right to carry on trade, business, and commerce. Of course, I don't think anyone really expected the challenge to be upheld and these sections to be struck down, because as we know now, that the right to claim input tax credit is a statutory right. It's that right by itself is not a fundamental right. It was given to you by statute by the parliament, and in the context of GST, it was in the form of Section 16. If the right to you is one which is created by the statute, can the same statute impose certain restrictions? The answer we all knew is yes. And therefore, the chances of constitutional success or challenge to the constitutionality looked very dim even from the outset. But the idea was to see whether we can get something which would be in the form of a percentage success to salvage the situation. Now, the court noted that amongst the two statutory exceptions, and 17(1)(d) spoke about plant or machinery. In other words, input tax credit was available under works contract in case of plant and machinery. So if you were constructing, giving a composite contract or works contract to, let's say, L&T for construction of plant and machinery, the credit would be available. Similarly, under 17(1)(d), credit would be available if it was for construction of a plant or machinery, albeit such plant and machinery may or may not be immovable property. The court, firstly, Supreme Court held that there is a distinction between plant and machinery on one hand and plant or machinery on the other hand. The Supreme Court had to decide this question because the government took the position that they are one and the same thing. The word or in 17(1)(d) had to be read as and. The Supreme Court said no, we will not read it as synonyms. We will read it as two distinct phrases because the parliament has consciously, in the same statute, in two different subsections, used different words, and we must respect the difference which the parliament has used. And the explanation which is given is only the explanation for plant and machinery. So we cannot say that there was a mistake on the part of the parliament in using the word or in section 17(1)(d). And we will hold that if it is either plant or machinery, which is a subject matter of construction, then the benefit will be given to the SSE. Now, in elaborating on this part, what the Supreme Court did and went a step further, and that was the positive, the positive part of this judgment is where they said that you have to apply the functionality test. What do you mean by functionality test? Now, if someone were to construct, let's say, an airport, which was one of the parties before the Supreme Court, or somebody who had constructed a warehouse, or someone had constructed a data center, the question is, are these not businesses? And I'm using the larger expression businesses, because that's how it is defined under the Act in the larger context. If these businesses are ultimately paying GST on the services rendered by them in the form of an output service, could the credit be denied? And could I not say, in the larger sense, that ultimately the airport or the warehouse that I'm creating, which is used for the purposes of my business or for the purposes of providing output service, is nothing but a plant as far as the investor or the person, the business person is concerned. And that is where the Supreme Court went into the various definitions of what constitutes a plant, including the famous case of Taj Mahal of 1971, where the Supreme Court held that sanitary wares in a hotel do constitute or become a part of the plant. So, using all those judgments, the Supreme Court in Safari Retreats held that if you apply the functionality test, and if you then come to the conclusion that the asset which is being created is the one for in furtherance of the business, then you would say that this is a plant and would fall within the exception to 17(1)(d). So a very big exception was carved out, and this opened the room for a lot of businesses to say that we would be eligible to take the ITC. As we know now that in the last budget, the Finance Act has been amended. Finance Act has amended the GST Act. And today we have a scenario where both 17(1)(c) and section 17(1)(d) use the uniform expression plant and machinery. Has this changed the ratio of Safari Retreats? Is the question which comes. This would not change the ratio of Safari Retreats. And in my view, therefore, if I can show that this is a plant for the purposes of my business, and even if you read the words plant and machinery, so typically if you are having an airport, you will have conveyor belts, you will have various other equipments installed, the machines, apparatus, and equipment which are used for facilitating aerobridges is part of an equipment which is attached to the structure. There are several. Similarly, a port. Similarly, in a warehouse, you may have a warehouse where there may be packing and packaging activity, logistics activity going on, and there may be some stackers, there may be some forklifts, there may be some other equipment which is lying in the warehouse. So ultimately, I think where it comes to, and that is again the broader principle, that if the value addition suffers the tax at the last stage, then all the credit at anterior stages or stages before the last stage should be made available. And if one goes back into the point of history, one will recall that the Bombay High Court had an occasion to deal with this situation in Hindustan Coca-Cola and said that ultimately in Hindustan Coca-Cola, what were the facts? The facts were that the SSE was supplying concentrate, and the concentrate was being sold to the bottlers. The bottlers were advertising, and the SSE, who was manufacturing and supplying concentrate, also bore the expenditure on marketing and advertisement of the final beverage or the final product. The Bombay High Court held that you cannot be told that just because I manufacture concentrates and I don't manufacture the final beverage, I will not take the credit, or I will not be eligible to take the credit of the service tax paid to an advertising company, and said that if ultimately in the concentrate value, I am going to include all this expenditure and pay tax on the concentrate, mind you, it was excise duty in those days, I cannot be denied the credit. Extend the same principle now to the GST scenario and apply it to section 17(1)(c) and D. If GST is tom-tom to be the tax on value addition, if it was announced to take care of the cascading effect and reduce the incidence of tax in a transaction, then I don't see how the principle laid down in Hindustan Coca-Cola, read with the functionality test, would apply even today, despite the amendment to the Finance Act in 2025. So I know it will again throw up new challenges. It will mean multiple rounds of litigation. But I think if read in the right spirit and in the right mind, Safari Retreats is here to stay and has provided sufficient relief to the SSEs. The beauty of this judgment is that the department claims it's their victory. And when both sides claim that it's a victory by them, and both sides tend to read the judgment in their favor, obviously the challenges for the future will be, and it will result in multiple litigation. But if I were to put my view on the subject, then I would say that until it is disturbed by a larger bench, Safari Retreats will be good law. And this amendment, which has changed from plant or machinery to plant and machinery, does not take away the ratio of the judgment insofar as the functionality test is concerned. Unfortunately, the two exceptions which Safari has also mentioned and has foreclosed the discussion on that is hotels and cinemas because of Anand Theatre line of cases. So they didn't want to, two judges deciding Safari Retreats did not want to overstep and unnecessarily refer the matter to the larger bench. But someday, I think even hotels and cinema will have a case to argue that they also, like all other businesses which I mentioned, also will be classified as plant and machinery, because at the end of the day, hotels also pay substantial amount of output GST. The next judgment is again something which has raised several debates already, and that is the judgment which will be on the next slide, of the Kerala High Court in the case of Indian Medical Association. A judgment which has today tried to once again go back in point of time to the service tax law and applied it to the GST regime. And what, if I may summarize it, this judgment can be popularly called as a judgment on mutuality of interest. Now, where have we picked up this clause or phrase of mutuality of interest, it has emanated in the context of taxes, in income tax and various other laws, to say what is for the person, by the persons, and of the persons. To use the expression which Abraham Lincoln would have used has used in the context of democracy, to say that if service tax presupposes that there have to be a minimum of two persons, namely the service provider and the service recipient, then in that scenario, unless and until the revenue establishes or proves to the fact that there are two distinct persons, the judgment uses the word plurality of persons, then in that situation, only can the tax be levied, because then one is rendering service to the other. However, the judgment comes to the conclusion that when an association deals with its own members, and whatever contributions it receives from the members is plowed back for the benefit of the members, then in that scenario, there are no two persons, it's the same person. And it being the same person, there cannot be a service to oneself. Nobody can render service to oneself. And on this premise, the High Court has held that service taxes, GST is not payable by the Indian Medical Association, who were the petitioners before the court. Now, what are the challenges in this kind of a judgment? Should it be readily accepted? Should people alter their position? Should now societies, like in Mumbai, we have a lot of cooperative societies, housing societies, should they change their position? Should organizations such as your organization or several other organizations which have a large members base, should they now say that we are doing that they invoke the principle of mutuality of interest and stop paying GST for those who are already paying? These are questions which are being raised and debated. We all know that Section 7, which defines supply and was amended in 2021 with retrospective effect. This now supply of services by an association to its own members or persons, whether that association is incorporated or not, it will amount to a service and tax will be payable on that supply. Now, is this something that the parliament is competent? The Kerala High Court overcomes this by saying that this particular provision is ultra vires the Constitution. Why? Because the Constitution does not, like Article 366(29)(a), which came by the 42nd Amendment to bring in certain changes in the sale of goods as defined earlier in Gannon Dunkerley way back in 1958. People recall that in 1958, the Supreme Court held in Gannon Dunkerley versus State of Madras versus Gannon Dunkerley that for it to be taxed as a sale, there should be a transfer of chattel to chattel for consideration. And in a works contract, since there is no such passing of property in goods directly, it cannot be a sale. The Constitution had to be amended, and that's how it started being subjected to tax. Drawing the same analogy, the Kerala High Court then has come to the conclusion that there is no ability in the parliament because of the lack of provision in the Constitution, similar to Article 366(29)(a), that you can define service or supply by a legal fiction. Now, I am not totally in agreement with the ratio, because the parliament, in the context of a provision like this under Article 246(a), now that we have a new constitution, so we have to forget that there is a list 1 and list 2 and list 3 for the purpose of GST. As you know now, from Mohit Minerals to Tirumala and another line of cases, Article 246A has not only been held to be the source of the power to legislate on goods and services tax, but also the field of legislation is prescribed therein. There's no separate entry in any of the lists. So we have to look at 246A. In my view, you don't have to deal with a situation like amending Article 366(29)A. In my view, Article 246A is broad enough to bring within its ambit the plenary power to the Parliament to legislate on any topic, whether by way of direct impact or the legal fiction. This is more so because the definition of service is almost like a residuary service, a residuary definition. Because what it only excludes are two things. It excludes transactions in goods and transactions in immovable property. Other than that, there is no fetter on the power of the Parliament to come up with an amendment. So although today Kerala High Court has respectfully to say overcome the bar of the amendment in section 7(1)AA, we will have to wait and time will tell us whether this will be upheld by the Supreme Court. I'm sure that there will be a challenge. I was informed, but I haven't seen anything. I was just informed that there is a move that there is an SLP which will be filed, but I'm not sure whether it has been filed, and I've not seen anything in the media reporting to that effect. But the last word must come from the Supreme Court on this, because even though the Kerala High Court relies on Ranchi Club and Calcutta Club, both are judgments of the Supreme Court in the context of service tax and the sales tax law of the respective places. Calcutta Club dealt with the West Bengal sales tax law. They had similar provisions as we find them in section 7(1)AA. The question is that how is GST so very different from the earlier regimes, which were either in the domain of list 2 or in the domain of list 1, which was that scenario. And mind you, even subsequently, the Supreme Court in Yum Restaurants, a two-judge bench, did not apply the ratio in Calcutta Club. Obviously, it did not say that Calcutta Club is not good law, but in Yum Restaurants, on the facts of the case, they came to the conclusion that the mutuality of interest doctrine will not apply. So this is still a gray area. We'll hope that it is decided in favor of the SSC, but for the moment, it is thrown up important issues, and one will wait to see whether this doctrine is here to stay for long. And to make the matters more complex, what will really happen at the ground level, at the practical level, is there is hardly an organization or an association which is catering only to the members. And there are associations and organizations which deal with third parties and have transactions with third parties, maybe as part of the events for the members, or maybe in connection or in conjunction with what it does for its members. But there is some kind of relationship with third parties also, and most of the time that is at a charge or at some consideration. So given these challenges, whether mutuality of interest doctrine will apply only to when the transactions are with members, or is it also, or there will be no benefit available if third-party transactions, and can you segregate the two? And if you segregate the two, you will end up with a situation of one exempt services and the other non-exempt services, which in turn will credit, whether input service or input on goods, those will be have to be segregated, and again, separate challenges of separate accounts, etc., and exclusivity and common in credits. With that comment, if I may just go to the next. This is the judgment of the Nagpur bench of the Bombay High Court. This judgment dealt with a development rights agreement. It looked at entry 5B in a rather, should I say, limited way or in a truncated manner, and recorded a finding that there is no transfer of FSI, and hence entry 5B is not attracted. And if entry 5B is not attracted, then the question of the payment of tax on development rights agreement will not arise. What it interestingly records is that entry 5B does not cover rights derived by the developer from the owner, and it has construed entry 5B to apply to transfer of developed transfer, and said that therefore this would apply only to a scenario where TDR, transferable development rights, are transferred along with the right to develop. I am not sure whether this narrow view will be subscribed by several high courts in the context of entry 5B. There are, I think, well-known material which is available with the department that development rights by itself, the transfer of the development rights by an owner of a land for consideration in cash or kind or a mix of both, would amount to a service by itself. And therefore, maybe the judgment in the case of Srinivas Realcon will be confined to the facts of that case and may not have large scale or larger ramifications, and the SSEs would do well to see that they take a very conservative view when it comes to transfer of development rights. I don't read 5B, entry 5B in that narrow sense. The literal interpretation has to be afforded. As we all know, the golden rule of interpretation is to give literal meaning and take the strict meaning as far as the tax laws are concerned, and not a meaning which will really do injustice or destroy the very essence of the taxable entry by itself. With that, let me go on to the next judgment. This judgment is also a much discussed judgment recently and has thrown up again a lot of new thoughts, a lot of challenges as well. This is a judgment in the case of Gujarat Chamber of Commerce by the Gujarat High Court. It's common in almost all states of the country that there are industrial development corporations. In Maharashtra, we have the MIDC, in Gujarat, you have the GIDC, so on and so forth. Obviously, these are statutory organizations. And in fact, the Bombay High Court pre-GST had a judgment of the division bench to say that MIDC does not render statutory functions. It does render only statutory functions and is not discharging any service. And therefore, the law has been amended and this kind of a situation has been taken care of. Of course, there are also equally exemptions when the leases are beyond a particular number of years. But let's take this scenario. This scenario does not deal with the original allotment to the lessee by the Industrial Development Corporation. This is not a case where we are dealing with the first transaction, the original transaction, whereby GIDC or MIDC gave the land on lease for the development purposes. That transaction is different. Here we are concerned with the second leg of the transaction, which is to say that if the original lessee decided to transfer his lease to a third person, what would be the implications as far as GST is concerned? Of course, such a transfer is permissible under the original lease, and such a transfer attracts payment of a certain premium amount to the concerned industrial development corporation. So the original lessee has, as part of his original lease, the right to transfer the lease subject to approval on payment of premium by GIDC or MIDC, as the case may be. And the transferee then will execute a fresh lease with the concerned authority. However, the argument was that insofar as this lease, transfer of lease is concerned, since it also involves certain consideration flowing from the new lessee to the old lessee, in addition to the premium paid to the Industrial Development Corporation, would it still be a transaction which is subject to GST on assignment of leasehold rights? Because that would be considered as a service, that you are giving up some right, you're giving up some privilege, and you're transferring that right or privilege into a third party. The argument was that no, it will not, because this kind of a transfer of leasehold rights creates an interest in an immovable property. And since any interest in an immovable property would amount to a sale or permanent transfer of that interest, it would be covered by Schedule 3, which we know Schedule 3 to the CGST Act deals with transactions which are not regarded as transfer of goods, sale of goods, or supply of services. So it's neither supply of goods nor supply of services, and hence would not be liable for GST. That was the argument. And that argument was upheld. And the effect of stamp duty was also pressed into service, that look at the Stamp Act of the respective states. It is a deemed conveyance. Because it is a deemed conveyance accompanied by the fact that there is a permanent transfer of an interest in an immovable property, it would be a sale of an immovable property and hence outside the purview of GST. Now we know that in builders and promoters case, the Bombay High Court and the Allahabad High Court in the case of Noida Industrial had rejected the same argument in the context of service tax. The Gujarat High Court has noticed it. In fairness to the Gujarat High Court, it's not that that judgment is where it does not notice a particular law or a binding judgment. In any case, Bombay and Allahabad would not be binding on Gujarat, because under our constitution, under 226, the territorial jurisdiction of each High Court is well defined. But they notice it in fairness. And they've come to the conclusion that notwithstanding those judgments, we still hold that since there is a permanent transfer of our interest in an immovable property, it amounts to a sale of an immovable property and hence outside the purview of GST. On first reading, the judgment looks very attractive, and the judgment probably will create a large degree of euphoria in the assessees that this is a benefit which we were not expecting. But again, maybe my cynicism and my skepticism does not permit me to share the same euphoric the mindset. And I would still wait for this judgment to be tested in the Supreme Court. It's an interesting issue. Under Income Tax Act, there are judgments which were cited before the Bombay High Court, but the Bombay High Court distinguished, which say that in such a situation, it amounts to a sale, it amounts to a transfer of ownership, and the person, the developer, can in his books of account show this as an asset that he has acquired. Now, different laws have different provisions. In different laws, there could be different legal fictions created by the parliament for the limited purposes of those laws. Whether you can extend the legal fiction, for example, in the context of stamp duty, to a GST, which otherwise recognizes lease as a service, whether that extension of a legal fiction is justifiable or not. The fact that lease per se and doesn't doesn't have any reference to the number of years of the lease. If the lease per se is covered by Schedule 2, then just because it's a permanent transfer of a leasehold right and the number of years is 99 years or a portion or a part thereof, will that really shift the transaction from Schedule 2 to Schedule 3 is a question which begs the answer. And only again, time will tell us whether this decision is good law or not a good law. In my view, Schedule 3 may have to be read in a very narrow sense that there is to be a transfer of title for consideration. Whatever be the terms and conditions of the lease, at the end of the day, it is still a lease. The lessor retains reversionary rights. And if we look at the Transfer of Property Act, the lessor has reversionary rights which he can independently sell subject to the lease. Now, if that be the scenario, as long as the lessor retains some rights and there is no absolute transfer of title in the land or the movable property, it is a question which will need an authoritative answer. We move to the next slide, please. This is a case of the Karnataka High Court, which decides a very interesting issue. Constructed building. The company went into winding up. The new buyer who purchased it purchased an under construction asset. The question was, is the new buyer liable for GST because he has taken a structure which has not been completed, in respect of which there is no occupation certificate, and therefore would service tax or GST be liable? The Karnataka High Court, and in my respectful view, the High Court has taken the correct position that this is not a case where the service is being rendered or there is any supply by the liquidator. Since the liquidator is only executing the monetization of the assets, the service is not being rendered. He is only there to see that the assets are sold and all the creditors are paid off. In such a scenario, there being no sale, no GST would be payable, and that is the correct ratio of this judgment. Sorry, the next one, please. Once again, a novel question which arose before the Goa bench of the Bombay High Court. And this was in the context of universities. Similar petitions, I understand, are still pending in the Bombay High Court as well, and probably in some other high courts. That is, again, I'm informed, but I have no direct knowledge. Where the question was that every university charges affiliation fees to the colleges and the institutions, who then can issue degrees or their students can claim that they have passed out of a particular university. GST department being adventurous, thought that this is a service being rendered by the universities, namely granting of affiliation, and therefore sought to tax the fees which were collected by the university. The High Court, again rightly, has held that university is not in the business of granting affiliation. It is part of the statutory function of the universities, which are set up under different laws. And it's not a case where the university is rendering any kind of a service. It's just a affiliation for the student to get a recognition that he or she has passed out of a particular university, and therefore the demand for GST was not justified. And the High Court rightly allowed the writ petition. Next slide, please. Aberdare Technologies again is a judgment of the Bombay High Court, which has really made law a living creature in the sense that to respond or react to the real-time difficulties or problems that may arise. We all know that there are timelines for filing returns. There are time and the manner in which it is filed. There are timelines for rectification of errors in the returns. But there can be extraordinary situations, and emphasize the word extraordinary because it can't be that every person will freely make use of these judgments, where a genuine error has crept into the return, which has no implications on the revenue. There's no loss to the revenue. And those errors are realized after the deadline for correcting of errors has passed, which, as we know, under section 37(3) and 39, is in the September of the following financial year. So, for example, for assessment year, for financial year 24-25, the errors can be corrected until the next year, September of next year. Now, situation then is that what happens if the error is realized after the deadline has passed? The Bombay High Court, following its own earlier case in Star, came to the conclusion that you have to read implicitly in the language of section 37 and 39 that if the error is genuine and there is no loss cost, will suffer a disadvantage or a prejudice by that genuine mistake, cannot be a ground to disallow or deny such a correction of an error or a mistake. And it is in that spirit that the Bombay High Court passed this order. It's definitely a positive development as far as the taxpayer is concerned. But with the caveat that I will introduce is that this judgment does not give a free hand or an open hand become a kind of a license for mistakes to be rectified as and when somebody wakes up and then chooses to say that I will rectify the mistake. It has to be shown that this mistake was genuine or a bona fide, and that there is no loss to the revenue. Until these two twin conditions are satisfied, I would say that one cannot freely just rely on this and be lax in filing returns. Can we go to the next slide, please? This is a judgment of the Madras High Court, where the argument was that I have not been served with the order and there's been no communication of the order to me. And the Madras High Court said that if the order or notices under GST are uploaded on the GST portal, then that is a valid service to the SSC. And this seems to be now an increasing trend, because when we look at NGT laws, National Green Tribunal, or we look at SEBI, I think all orders are uploaded, and that is the beginning of the communication, and therefore limitation begins to run from the day on which the order is uploaded. Yes, many institutions like NCLT do also upload orders, but then there is a system of a pronouncement. But as far as the regulators are concerned, and of course, I would not put a GST assessment in the context of a regulator, but I'm just trying to draw the inclination of various courts and tribunals to lean towards the uploading system, there where uploading is looked at positively and is a advancement of technology, and courts have said that therefore anything that is uploaded on the portal, your limitation to react, to challenge, and to act upon that order or notice starts. So this is something that we need to be very careful about. I think henceforth all the SSCs will have to sit up and excuse that I was not taxed, especially with the faceless. Everything is online and uploaded. And hence today, this is only a judgment which puts its stamp on such a practice that is being followed across the board by various regulators, by various authorities and tribunals, that the moment a notice or order is uploaded, it is deemed to have been. There are two judgments, this one, Citibank, and the next one, which are not judgments in relation to GST, but under the erstwhile service tax law. But they are very, very important on the principle that they lay down. Take the first case of Citibank. This is in relation to credit card. As users of credit card, we know that we go to a merchant or an established business establishment, use our credit card. You may give a card, but the payment gateway of Y Bank, because that machine, the POS, the point of collection, the point of sale is with some other bank. So when he uses your credit card issued by Bank X and collection is by Bank Y, there is what is known as a merchant discounting rate, whatever it may be, 2%, 4%, or whatever. The merchant deducts that 4%, whatever that 2% is, and pays that much less to the bank deducts that and pays that much less to the merchant. Out of that 2% to the issuing bank, which has issued the credit card originally, whatever that arrangement is. I'm just giving a hypothetical example. Question arose that if the collecting bank had paid service tax on the full amount, the entire 2%, which is the merchant discounting rate, would the issuing bank, which takes a part of that 0.5%, be once again liable to pay the service tax? And the Supreme Court held, no, it is not liable. The revenue's argument was very simple, that why can't it pay tax on 0.5 and take the credit? Because that's how the chain of the tax credit is maintained. But the Supreme Court said that since you have already got your pound of flesh on the entire 2%, why would you want somebody to once again pay tax on 0.5%, especially when you say that it is revenue neutral and he can just take the credit of that tax paid on 0.5%. So now if we were to apply this in the context of ramifications, and just to take a case in point of time, recently, in the context of insurance industry, for insurance and co-insurance, the circular has been issued to say that in such a scenario, the ratio like that one of Citibank, of course, there is no reference in that circular to the Citibank judgment, but adopts the same principle to say that in such a scenario, once the lead insurance company, has paid this tax on the entire amount of the premium, then all the premium that it distributes to the other consortium members will not be again liable for payment of GST. So this is an important judgment, lays down a very important principle, which will also have bearing on GST. The second judgment, which I referred to, again in the context of service tax, is the case of Bharti Airtel. We all know that mobile companies use mobile towers, and the mobile towers may be provided by or erected by mobile infrastructure providers, service providers, who then erect these towers, would take input tax credit on the construction and erection of these towers. And if people remember, the language used in the Senvat credit rules 2004, the language was inputs used in the manufacture of or in relation to used in relation to or for the manufacture of the final products or for providing output service. And they should be also available in the context of capital goods. The word goods, when it was associated with the word capital, meant that the capital goods which were in the form of immovable property would automatically not be part of the definition of capital goods. So the argument of the revenue was very simple, that these towers are immovable property. They are erected on the earth and they get attached to the earth, and therefore no input tax credit should be allowed. And the Supreme Court came to two findings. One was a finding of fact, namely that these towers are not immovable property. These towers are brought in the SKD, CKD condition to the site. They are prefabricated structures, and after they are erected, they may have some immobility or immovability. But at the end of the day, they again, if one removes them or detaches them from the earth, then they would cease to be immobile property, and followed its own line of cases in Sirpur paper mills and also solid constructions case, and came to the conclusion that these were not immobile property. So that was a finding of fact. What it also came to the conclusion was that they, in any event, independently of the fact whether they are immobile property or not, and if I remember the para correctly, that entire discussion starts from para 11.12, that in any event, they are inputs used for providing output services, the inputs which have gone into the making of the prefabricated towers. So those inputs are required for providing output services. And hence, on that count also, the credit cannot be denied. Now, why I included this, because I found a very interesting, and if I was going to do a little bit of an academic study and maybe figure out whether there is any underlying synergy between the two judgments of the Supreme Court, one in Safari and the other in Bharti Airtel. And if we were able to reconcile the ratio of these two judgments, one would say that the second part of the judgment in Bharti Airtel, which interprets the law, the legal provision, that's the definition of input and input services, then that would mean the functionality test, because irrespective, the Supreme Court ratio would be, one could safely say that, in Bharti Airtel would be that without getting into the question whether the resultant product is an immobile property or not, look at the purpose for which it is used. If the purpose for which it is used is to provide output service, then you cannot deny the credit. Extend the same principle or the same logic in the context of Safari. The word purpose in Bharti Airtel can be read with the word functionality in Safari Retreats. And if I read Safari Retreats to say that functionally, if the resultant product is something which is needed for you to provide output service, and then you will not be denied the input tax credit. So it will be an interesting scenario to see one day the courts trying to reconcile and harmonize the two judgments and probably widen the ability of assessee to take input tax credit, which would, of course, be a breath of fresh air. With that, I think I have run through the few judgments which I thought were important, and I had them at hand. I now hand it over back to Mandar to take it forward.
Yeah, thank you, Vikram bhai. It was really a nice and enlightened session. There are maybe we have some time, maybe 5 minutes to take up some of the questions that have come up in the question answers blog. So some of them you have already addressed upon, but there is one question on the recent judgment of the um, Arya Cotton Industries in the Gujarat High Court, where the question was when a particular SSE is paying the amount in the electronic cash ledger, but he is filing the return subsequently. and the actual liability gets offsetted only when he files the return. So there is some confusion as to when the interest is applicable, whether it will be applicable from the date of filing the return, if there is a delayed filing the return, or once the amount is deposited in the cash ledger, that is sufficient. So there some amendment has happened just now saying that once the amount is deposited in the electronic cash ledger, then no need to. But what would be the impact of the past period?
Let's go to the bottom of it and understand what is the genesis of interest. Interest has been throughout, right from J.K. Cotton days, held that it is compensatory in nature. Why we call it compensatory? Because when the amount is due and it is not paid, further loss of time, the time value of money, as we call it in the context of IBC and insolvency law, ultimately that interest is nothing but the time value of money. So if the amount was not due until a particular date, or if I have already deposited that amount in the ECL and that is earmarked for that purpose, then rightfully so, interest would not be layable because you are not enjoying the benefit of that money as an assessee. You have now already earmarked it and put it in a designated account. The account is designated by law. You have no choice. You have followed the law and complied with it by putting the amount in the deposit. And therefore, as long as you as an assessee are not going to use it and you have not deprived somebody else from using it, then in that context, I think the amendment is only one would contend, and perhaps rightly so, that the amendment would have the same effect for the past period. And in a way, it should be viewed as clarificatory in nature.
Okay. There is another judgment on this mutuality decision that you rendered, that whether it says that the past transactions are outside the purview of GST, or will it applicable to only prospective transactions? What is the position?
So prior to amendment, although it says with retrospective effect, somebody will have to challenge it, and I would apply the principle of Vatika Township, which is a leading judgment under the Income Tax Act in the context of Section 113. That i- prior to that, there was no liability, and you cannot create a liability with retrospective effect. And therefore, in my view, prior to 2021, when the amendment came in Section 7(1) AA, there should not be any tax implication.
There is one more question we will take. This is about the safari retreat, whether it would be applicable on the constructed office space for leasing.
So Safari was a case of leasing itself. Um, One will have to again apply the test and see. Firstly, the way today department is looking at Safari is to see firstly whether you fall under 17(1)(c) or 17(1)(d). That's one. Second, they are saying that in view of the amendment which is now made under the Finance Act, the only exception is that if you satisfy the twin test of plant and machinery, and therefore para 66 of Safari, which deals with functionality test, is no longer good law. It's not applicable to you. The moment you do not qualify as plant and machinery, then automatically the credit will be denied. Now, in the context of a mall, I dare say that there will be any plant and machinery, one who cannot call it as a plant and machinery. So it will result in one more round of litigation. And as I said earlier, in my view, the functionality test is a universal test. Whether you change the language from plant and or machinery to plant and machinery will not destroy the ratio of the functionality test, but the department may not readily accept it.
Yeah, there is one last interesting question. As you mentioned that your interest is compensatory in nature, there is one provision under section 16 which says that if you do not pay to the creditors within a period of 180 days, then whatever ITC you have taken, you have to reverse it along with interest. And when you pay it back, you can reavail the credit. So the question is about that interest that is liable to be paid, which is really speaking, the department or the government is not at loss. So whether such kind of an interest could be considered as a compensatory levy, penal levy, or what is your view on that?
Yeah, so I mean, you use the right expression. This is more in the nature of a penal provision. And one will have to again debate it out to and show it that merely taking of the credit is different from utilization of the credit. There are two different aspects of it. If I utilize the credit, there is no brainer, then I'm liable for interest. Question is, if I've taken it in my books but not utilized it and at all times maintained the minimum balance of the disputed amount, then would I be liable for interest? Is, in my view, not the correct position.
Yes. So thank you, Vikram bhai. I hand over the proceedings to Dushyant bhai for the vote of thanks and other announcements. If any. Thank you.
Yeah. Good evening, all of you. Before the pleasant task of vote of thanks, there are a few important announcements which I would like to deal with. So BCS at with the coming events, we have 4-day study course on Foreign Exchange Management Act, that is FEMA. The dates are on 30th and 31st of May and 6th and 7th of June. The mode is virtual and not the physical. Then we have an important event on supply chain and gold mine for internal auditors, which is on 6th of June, Friday, and it is at Ginger Hotel, Villaparle. Then we have a webinar on opportunities for CS in Oman, and which is on 10th of June, Tuesday, which is on virtual mode. We have our 19th residential study course on GST, which is placed on 12th to 15th June at Kolkata West in Rajarhat. I am proudly, announcing that the subscription is closed, and we at BCS and IDD committee are thankful for all the participants. Then we have 29th International Tax and Finance Conference, which is placed on 14th of August to 17th of August, and which is at Ananta Spa and Resort, Jaipur. So with this forthcoming event, now I come to the pleasant task of a vote of thanks to learned speaker for the day, for the evening rather. On behalf of BCS, I extend our heartfelt thanks to Senior Advocate Mr. Vikram Nankani, sir, for delivering such an insightful and engaging lecture on the recent jurisprudence in GST, and that too covering more than 10 such big, round of this jurisprudence in such a short time. Sir, your deep understanding and clear explanation of complex court rulings have certainly added immense value to all of us present here. We are grateful to your time and for sharing your expertise with such clarity and precision. Your perspective on evolving legal landscape in GST will surely guide all of us in our professional practice. Thank you once again for being us today. We look forward to more such enriching session in the future. I, on behalf of BCS and all present here on virtual meeting, that was more than 300 today. Thank you for your time out of your busy schedule, and would request all of those who have joined with a loud round of applause. Thank you very much.
Thank you,
Thank
Vikram.
For your
Thank you.
time.
Thank you so much.
Well,
Thank you
right.
very much.
Thank you.
Yeah, thank you.